ways to do it.
Yeah, war organization.
But isn't that,
It's not her fault, the calendar said 9:15.
That's all right, Your Honor, extra time to prepare is always welcome.
To gather her thoughts. All right, let's go on the record now, CD 14-383, John Brakey versus Santa Cruz County Board of Supervisors. This is the third day of our special action hearing. And let's start with
Alexander Collin, appearing on behalf of all plaintiffs.
John Holman on behalf of the defendants with me, Charlene LaPlante also on behalf of the defendant.
my understanding, Mr. Collins, you will please call a witness before going to closing argument.
Yes, Your Honor, I would like to recall Mickey Donahoe to the stand.
Mr. Donovan? Sir, you're still under oath. Give him a chance to get settled. Go ahead, please.
Good morning, Mr. Donahoe.
Good morning.
Can you please once again state your name for the record?
Michael Duniho, D-U-N-I-H-O.
Okay. Now, Mr. Donahoe, you understand we're here today to talk about solely request number 10?
Yes.
Okay. Now, Mr. Donahoe, have you had a chance to review any of the items disclosed by the county since our last court session?
Your Honor, the state can object to this line of
Your Honor,
questioning.
we'll draw the relevancy between this and number 10.
It's not a relevancy argument, Your Honor. As a rebuttal witness, I believe that Mr. Donohoe is limited to rebutting the testimony presented by the defense. Defense didn't ask any questions regarding record request number 10 to its only witness, Ms. Meek. So I would object to any questions referring to request number 10 because they go beyond the scope of rebuttal testimony.
Okay. So, Mr. Donahoe, did you have the chance to review those documents?
Yes.
And in your opinion, as a computer expert, after reviewing those documents, would the disclosure of number 10 assist the plaintiffs in evaluating whether those requests have been fully complied with?
They might.
And why
Yes.
is that?
Because it appears in the audit trail, which was number 7, it appears there might have been some missing data. It also appears that possibly the database was programmed externally to Santa Cruz County, and number 10 deals with network connections and might give some information about whether anybody outside of Santa Cruz County had access to the central count computer.
Okay. And so now let's get to the rebuttal issue, as the defense has pointed out. Ms. Meek, when she was on the stand, testified as to the logic and accuracy test. Explain what that was a little bit. Can you tell us if the granting of request number 10 would provide something that the logic and accuracy test would not?
Yes. The logic and accuracy test only tells you that somebody programmed the database so that it has the correct races and candidates in the database on a particular day, namely the day that the Secretary of State did the logic and accuracy test. Unfortunately, because the computer is a black box, that doesn't tell you anything about what happened on election day. It only tells you that the computer was working a week or so before the election. And it's entirely possible for somebody to program the database so that it does one thing during the logic and accuracy test and something different on election day. It is also possible, if you have network connections, to change what the software is doing on election day from what it did during the logic and accuracy test.
Okay. So, do I understand correctly then, are you saying that number 10 allows, would allow independent verification, that no one is getting around the logic and accuracy process? Would that be a verification?
Objection, leading, Your Honor.
Okay, well, fine. I will rephrase the question. Are you saying that number 10 would allow for some sort of independent verification?
Yes, in the sense that if you could show through the response to number 10 that there was no network connection, then that would at least rule out one possible source of fraud occurring on election day or during the counting of early ballots. It wouldn't rule out all possible avenues of fraud, but it would be one avenue of fraud that you could rule out.
Would a logic and accuracy test also allow this avenue to be ruled out?
No, unfortunately, the logic and accuracy test is not designed to rule out fraud at all. The logic and accuracy test only tells you that the database was set up correctly.
Okay. Your Honor, we have no further questions at this time. Mr. Duniho.
Thank you, Mr. Holby.
Mr. Donahoe, are you being paid to be an expert in this case?
After 3 days in court, yes, I hope to be paid.
And what is your payment agreement?
My payment
Your objection,
agreement.
Your Honor, relevance.
I don't have a written payment agreement. I don't have a contract, if that's what you're asking me.
At what point did you decide that you were going to be paid in this case?
After I found out we were coming back for a second day.
So through the first day, your services were being offered for free?
I would have been willing to have no pay after the first day if the case had been settled at that point.
But there is no actual agreement to that effect?
Objection, Your Honor, asked and answered.
I don't believe so, Your Honor.
There is no agreement. There is no specific agreement about anything. I was told by Mr. Colladin that after the case is completely settled, I should submit a timesheet and we would go from there.
And what's your hourly amount?
The hourly amount that I propose to charge is $200 an hour.
And when did you convey this amount to plaintiff's counsel?
When we first talked about my being paid,
And when did that first conversation take place about being paid?
after the first day.
And by that you mean after October, I believe the first day of the hearing, October 1st, roughly?
Whatever the date was, yes.
And prior to that, there'd been no discussions about being compensated?
There had been discussions about my being compensated, yes.
Okay, but you decided that if it only resolved itself after one day, you wouldn't be charging any money to the plaintiffs?
I had decided that. I had not had any discussions with Mr. Colladin to that effect. I had not specifically offered anybody free services at any time.
Okay, but for the last 10 years, you've been volunteering several hundred hours a year.
I've been volunteering time to Pima County for the last 10 years. But that was not as an expert witness in a court case.
Okay. Have you ever been an expert witness in a court case before?
Yes,
And were you paid in that
yes.
experience? And how many times have you been a paid expert witness?
I have been a paid expert witness in 3 different court cases.
And during those, and how many times have you testified for the defense in those cases?
For the defense. In one case, I testified for the defense.
And that would be the agency responding to a public record request?
No, that
There
was,
public record request.
that was a computer contract case involving Dell Computers, in which Dell Computers was being sued by one of their customers, and I testified for Dell Computers in that case.
Okay, and in those 3 cases where you previously testified as an expert witness and were paid, did you decide to be paid midstream as well?
No.
So those went.
And I didn't decide midstream in this case either. I started out expecting to be paid, but I was told after the first day that if the case was settled, that the county might not pay Mr. Collidan very much money. And I said at that point that if we didn't have to go back to court, that I would consider donating my services for that first day. But that was just a brief conversation that I had with him. But I had started out when I was first asked to be an expert witness, I was initially expecting to be paid.
And who asked you to be an expert witness in this case?
Mr. Collidan.
And when you were initially contacted by Mr. Collidan, what did you relate to him about the charge for your services?
I don't think that we discussed the charge for my services specifically.
Objection. This line of question, it was Dr. Gagnotti who testified on the first day that he had no expectation of payment. This question was never even asked of this witness, so it seems a bit irrelevant at this point.
So I guess I'll repeat the question. I don't exactly remember how I phrased it. But at what point did you first have a conversation with Mr. Collidan about fees, about how much you would be charging in this case?
About how much I would be charging? I have not had a conversation with Mr. Collidan about how much I would be charging.
Okay. What about what your hourly rate was with Mr. Collidan?
I think that's the same question and the same answer.
So you've
I
never
have not had a conversation with Mr. Collidan about the fee or the rate that I was charging.
Okay. In the previous 3 times that you testified for pay as an expert witness, was that a flat rate or was that an hourly rate that you charged?
It was an hourly rate.
Okay. And was that hourly rate decided before or after you provided testimony?
After I provided testimony.
On the previous 3 cases you testified.
I simply submitted a bill.
Okay. But there was no agreement beforehand in those previous 3 cases what your hourly rate would be?
No, I was not asked what my hourly rate would be.
Okay, what were the names of those cases that you previously testified on?
I could not tell you the names of the cases.
What, were they all in Pima County?
No, the Dell case was in Texas.
And what county was that?
I don't know.
And what year was that?
I'm not sure. It was back in the 80s, I believe.
And what city?
Probably Austin.
And what was the name of the other party?
I don't know. I don't remember.
And can you tell me as much information as you can about the other 3 cases, the parties, the locations, the years?
The other cases were in Pima County, and they involved elections, and I was testifying for the plaintiffs.
And what year were those?
I know that one case was in 2012. One case, my testimony was probably in 2007 or 8.
And who were the plaintiffs in those Pima County cases?
The plaintiff's lawyer was Bill Reisner. I couldn't tell you the names of the plaintiffs.
In both of those Pima County cases, they were represented by the
No,
plaintiffs were represented
in one of them it was Bill Reisner, and in the other was I don't remember the name of the other lawyer right now.
And who were the actual plaintiffs in those cases?
I don't remember.
Was John Brakey a plaintiff in either of those cases in Pima County?
He might have been.
And who were the defendants?
The defendant would have been Pima County. or Pima County Election Department. I'm not sure of the exact defendant.
No further questions, Your Honor.
Any chance that Pima County case was Celia Cruz, was called Cruz versus Pima County?
No, I believe the Celia Cruz case was with the city of Tucson, and I was not involved in that.
With regards to discussion of fee, did we ever discuss, in the context of a larger settlement, what your fees might be, without giving any details? Was that a discussion that we ever had?
In a larger settlement,
Yeah, in the context of settlement, did we ever discuss what your fees would be?
we did not discuss the specific fee. You just told me that I should submit a timesheet and a bill, and we would go from there.
Okay. And for the questions for the witness, Your Honor?
Sir, you can step down. Any other witnesses?
No, Your Honor. Yeah, no, for the witness.
Mr. Moore?
No, Your Honor.
Rosen?
I seem to give a dry closing, Your Honor, but I'm going to lead with the law here. Records are defined in A.R.S. 41-151.18 as all books, papers, maps, photographs, or other documentary materials, regardless of physical form or characteristics, including prints or copies of such items produced or reproduced on film or electronic media pursuant to A.R.S. 41-151.16, made or received by any governmental agency in pursuance of law or in connection with the transaction of public business, and preserved or appropriate for preservation by the agency or its legitimate successor as evidence of the organization, functions, policies, decisions, procedures, operations, or other activities of the government, or because blah, blah, blah. Okay. For guidance as to what electronic forms might constitute public records, we can look at A.R.S. 41-151.16, which provides us the guidelines for the storage and retention of electronically based information. That statute provides that each agency of the state or any of its political subdivisions may implement the program for the production or reproduction by photography or other method of reproduction on film, microfiche, digital imaging, or other electronic media of records in its custody, whether obsolete or current, and classify, catalog, and index such records for convenient reference. Network settings are thus public records for several reasons. The first is they fall into the broad umbrella of electronic media articulated in A.R.S. 41-151.18 and A.R.S. 41-151.16. The statute specifically states that public records include all books, papers, maps, photographs, or other documentary materials, regardless of physical form or characteristics. And network settings is a real-time visual record of, one, whether the computer is connected to the internet, and two, the computers that are connected to the network. And you've heard testimony to that effect today. Network settings are not statutorily privileged or confidential. There are over 300 Arizona statutes that address the confidentiality of records. Not one of these statutes defines these records as protected. Defendants argue that the release of number 10 would be invasive. And Your Honor, that is exactly right. It would be invasive. And that's because the Arizona public record statutes are themselves meant to be invasive. These are sunshine laws, Your Honor, and sunlight can make those hiding in dark corners uncomfortable. In any case, plaintiffs refuse to submit to the defense's parade of horribles. The issue of whether the Arizona public records law would allow citizens to inspect the work computer of a county official is not before this court. The only computer to which plaintiffs have asked for access is the vote tabulation machine. That machine is not assigned to one official. Rather, that machine is assigned to one official purpose, and that purpose is the tabulation of votes in democratic elections in this county. The public has a strong interest in ensuring that this machine is functioning properly and being used properly. In fact, one of the purposes of Arizona public records law that you find throughout the case law is to allow citizens to check up on their government and not have to take the government's word that it is conducting its affairs appropriately. And you've heard about the deficiencies of one of the mechanisms that the government uses for that, which is the logic and accuracy test. So, Your Honor, when the defense raises the idea that simply because logic and accuracy tests are run on a computer, that the public does not have a strong interest in obtaining number 10, they're not being faithful to the spirit of the law. And in any event, logic and accuracy is an extremely limited way of ensuring the proper functioning of a vocabulating computer. Logic and accuracy is nothing more, as you've heard testimony on, than a snapshot of the vote tabulation machine's ability to count a predetermined set of ballots at a predetermined and specific point in time. From what the defendants have disclosed in response to number 7, it cannot even be ascertained that the logic and accuracy test is being run prior to every election. Unfortunately, there's too much undisclosed and redacted material for plaintiffs to perform that analysis. Granting number 10 would help plaintiffs ascertain the veracity of the rest of defendants' disclosures. Furthermore, the specter of invasiveness is mitigated by the manner in which plaintiffs have requested to inspect the records constituting number 10. Although it is plaintiffs' right to inspect number 10 at any time during the county's normal business hours, plaintiffs have not requested to do so. Rather, they have told the county, you pick the time, you pick the day, within reason, and you provide your own personnel in the room, at the computer if necessary, if you like, in order to ensure that only the requested records are being accessed. Your Honor, in a public records action, it is defendants who have the burden of proving that a particular request does not constitute a disclosable record. The defense has failed to meet that burden. As an excuse, the defense provides the rationale that the court must apply a balancing test between the best interests of the county and the interests of the people in disclosure. Well, Your Honor, this balancing test is far from the 50-50 balancing test that the defense would have you believe. Rather, Arizona law provides a strong presumption that records, once requested, must be disclosed and that the interests of the people and transparency will be paramount. The defense has failed to meet that burden as well. Therefore, we are requesting that this court order the county to comply with plaintiff's request number 10 as written and would suggest within the next 10 days as a reasonable amount of time. We're also requesting that the court order that number 10 be disclosed in the manner specified in plaintiff's request. The law is clear and it demands no less. Furthermore, Your Honor, since defendants have still not disclosed requests 1 and 2 as stipulated, defendants have not had an opportunity to inspect these documents to ensure that the constructive contracts that we've requested, or the plaintiffs have requested defense look for, can be found within 5 years. Your Honor, the only reason that the original stipulation was to 5 years was because the county said that 5 years was all it would be able to produce by this court date, if you will recall. And plaintiffs agreed that if they could inspect these documents before the return date and ascertain that they contain the requested information, they would not need to request more years. Since plaintiffs have been unable to do that, plaintiffs are now requesting that this court order that the county's search for a constructive contract extend back to September 1st, 2002, the year and season that the county first formed a relationship with William Doyle. If records are not kept this far back, plaintiffs are requesting that the court order the release of these records as far back as they are kept. Thank you, Your Honor.
Your Honor, boy. I'd like to go, I guess first by recapping where we're at, Your Honor. The county and various agents, various departments within the county were sued by 9 plaintiffs. And the complaint that was, it was actually a 2-count complaint. Within that complaint was 10 itemizations of record requests that they're calling public record requests. And I'd just like to address numbers 1 through 10 right now. Probably more important, Your Honor, than what you heard through the course of these hearings is what you didn't hear. And I'll be pointing that out to you is you keep in mind, Your Honor, that the plaintiff has the burden of proof to establish that what they've requested is a public record. Only then does the defense have the burden to establish that releasing that information would be inappropriate and would violate the substantial interest that the public does have in access to information. So when counsel's saying that the defense has the burden, it doesn't. The burden lies with the plaintiff, as it always does, to establish that these are public records. In counsel's closing statement, he kind of intermingled records and public records. There is a big distinction between a record and a public record, and I'll get into that in a moment. But with respect to the 10 itemized list, and I'll just refer to them by number because the court has, we've been doing that all along. Numbers 1 through 4, Ms. Meek testified that they don't exist. There's been no rebuttal to that, Your Honor. The county has absolutely no relation relationship with the entity known as Runback. With respect to number 1, Ms. Meek indicated that she is the one that programs the central count election. With respect to 2, again, the county has no affiliation with Runback. With respect to number 3, again, no affiliation with Runback. With respect to number 4, there is no intergovernmental agreement or a long-term contract with Runback or anybody else. Numbers 1 through 4 simply do not exist as requested. Now, certainly, in the spirit of cooperation, the county has actually been extrapolating that request to kind of, we've been speaking about Bill Doyle, and that's because it came out that the county does use the services of an individual by the name of Bill Doyle. And so the county, in the spirit of cooperation, is trying to pursue all the records that we can with respect to Bill Doyle. And that was part of the agreement that we reached, that even though Bill Doyle isn't covered by request numbers 1 through 4, specifically 2 and 3, we can't simply substitute Bill Doyle for Runback. We can't do that, Your Honor. That would go beyond the scope of the public record request. The request was made on July 9th. The request was in writing by Mr. Brakey. The request was responded to by counsel for the defendants on August 7th. And it wasn't until, with respect to number 3, the county didn't even get the invoice from Bill Doyle until after the primary election, the end of September. And so at that point, Your Honor, again, I think the court can have no difficulty concluding that the defendants have complied with request number 4, because they simply don't exist. And that's exactly what the response that we provided states, that these simply do not exist. There's been no evidence to controvert that, Your Honor. With respect to numbers 5 through 9, that's a little bit trickier. In opening statements, counsel and I as well talked about the difference between data and metadata, and again, the definition of records and public records. I don't concede at this point that even 5 through 9 are public records. Having said that, in the course of in an additional spirit of cooperation, the defendants have released 5 through 9 as far as they understood those requests to be made. The plaintiff's own experts testified that basically request number 5, 8, and 9 are almost identical requests, just stated in different directions, or stated differently. Basically, plaintiffs in 5 through 9 have asked for directories, audit logs, and event logs, basically. But again, 5, 8, and 9, there's such an overlap, they basically are the same documents. And the defendants aren't making any parsing of whether or not these electronic documents or physical paper documents. That's not really part of any defense that we have. But again, the defense have disclosed 5 through 9 as far as we understood those documents. With respect to request number 10, and that seems to be the biggest issue right here, and I think the one that the court will have to invest the most amount of time assessing, I would point out to the court, and I believe counsel for plaintiff cited this as well, in Lake versus the city of Phoenix, and the citation for that is 222 Arizona 547. We have a definition of a public record, and it's actually quoting another case known as Matthews. A public record as 1, a record made by a public officer in pursuance of a duty, the immediate purpose of which is to disseminate information to the public or to serve as a memorial of official transactions for public reference. A record that the law requires to be kept or necessary to be kept in the discharge of a duty imposed by law or directed by law to serve as a memorial and evidence of something written, said, or done. Or 3, a written record of transactions of a public officer in his office, which is a convenient and appropriate method of discharging his duties. The Lake decision further addresses the fact that the court noted that the legislator had broadly defined a record but had chosen not to define a public record, instead deferring to the courts on this issue. The court observed that an enormous quantity of record is created daily in Arizona, but not all are public records. And in closing argument, counsel was arguing that request number 10 is a public record. Defendants couldn't disagree more with that, Your Honor. The request, as stated, says, we need to check various network settings on the central tabulators. This will be done by appointment. They want to check the network settings. From the defense perspective, that's the same thing as saying, I want to find out what your computer's screensaver refresh rate is. Go to the screensaver after 5 minutes or 10 minutes. That's what they're asking for is a network setting. I'll do one further, Your Honor. A lot of the county buildings have access codes to access either with a digital card or a key punch card. A network setting, that's what that is. It's, you know what, the network setting is we equate those with security settings, Your Honor. A network setting is not a public record.
It's not the testimony to that effect.
Your Honor, this is argument. The court can take it or leave it. A network setting is not a record made by a public officer in pursuance of a duty, the immediate purpose of which is to disseminate information to the public. What's the purpose of the network setting? Just to make sure the network's secure. And that's, Your Honor, and that's not a public record any more than it's a public record for anybody to show up to the jail and say, you know what, I want to inspect the bars on the jail cells to make sure that they're 12-gauge steel or some other spec. That is not a public record request, Your Honor. That is not a
We'll
public
repeat our
record.
objection. He's testifying, not arguing.
Inspecting a jail cell to make sure that the metal is of ample quality is not a public record. It's a request for inspecting something that has nothing to do with the public record as with the immediate purpose of which is to disseminate information to the public. The other interesting thing, and I alluded to this at the beginning of my argument, is that the request specifically asks, we need to check various network settings. I encourage the court to review all of the testimony presented by the plaintiff's witness and the one defense witness. There's been zero testimony that there even is a network. Mr. Duniho testified, Mr. Duniho testified that basically they have to be connected by network. You know, it's either going to be a landline or a telephone modem, or you know they'll have the access cards. There can be a LAN system. So we heard a little bit from Mr. Duniho about network settings and what his definition of a network is, but we've heard absolutely nothing from any of the witnesses to say that the county even uses a network system. And again, that's not the defense's burden to prove, hey, this is the network we have, and these are the network settings, and those network settings are secure. It's the plaintiff's responsibility to establish its case, to establish that request number 10 is indeed a public record request. And they failed at get-go because they haven't even established that there even is a network. In fact, if you look at the defense's response to request number 10, the server is not connected to the local area network. There's been no testimony to refute that as inaccurate, Your Honor. At this point, there's been no testimony presented that there even is a network, let alone that it is deficient, let alone that inspection of it is a public record right. Your Honor, back to what I was saying earlier about how this complaint started. It was a 9-party plaintiff complaint with 2 counts. And in looking at that, Your Honor, I'll look at the complaint. Count 1 alleges that the defendants have acted contrary to law in refusing to allow plaintiffs to inspect the requested public records. I believe I've addressed that. Number 1 through 4 don't exist. We responded, they don't exist. Number 5 through 9 may or may not be public records. The county isn't 100% convinced of that. I don't believe there's been sufficient testimony presented to that effect, but in the spirit of cooperation, we did release numbers 5 through 9. 10, wanting to show up and access a network in a secured area. And I use the jail analogy on purpose, Your Honor, because this central tabulator that the county uses, this isn't in a public location. This isn't at a library. This is in a secured area with limited access by personnel who have been vetted and are appropriate and tasked with the responsibility of going there. I can't just show up there, neither can any other county employee who just wants to. This is a highly restricted access area that Ms. Meek testified to is monitored every single election cycle. The Secretary of State shows up and makes sure that everything is in working order. The election process isn't a process without checks and balances. It's taken seriously by the county on a county level, but even more importantly, it's taken very seriously by the Secretary of State on a state level. And given all that, Your Honor, again, request number 10, it is not a public record request. So we've got count one. Basically, the county has failed to, publicly refused to allow plaintiffs to inspect the requested records. Count number 2 is the failure to properly maintain public records. And this basically says that even if the county doesn't have numbers 1 through 4, they should. Your Honor, the plaintiffs have failed entirely on that issue. Your Honor, there's been no testimony presented, no evidence presented that, you know what, the county needs to have a contract with Runback or needs to have a contract with Bill Doyle. We're kind of on a red herring here as whether or not there's a constructive contract with Bill Doyle, but that goes way beyond the scope of the record request that was made on July 7th. Again, the defendants are entertaining that notion and looking into Bill Doyle because we know that plaintiffs can just make an additional public record request at any time for Bill Doyle, the information related to Bill Doyle. However, while we're here today, the order to show cause hearing is with respect to what's on paper, the 4 corners of this public record request, and plaintiffs have failed wholly to satisfy that there was any violation of the defendant's duty to maintain records by count 2 of the complaint that's on page 6. I'd like to take this time now to address the party issue and also the attorney's fees.
Your Honor, we have a separate argument for the attorney's fees issue, just so you know. I thought we were addressing it as a separate thing.
It doesn't matter to me.
Well, he'll get rebuttal closing. I mean, Your Honor, here's why it's important. From the get-go, the county was sued by 9 individuals, 1 unincorporated entity, and 8 natural persons. From the get-go, the defendants knew that this was defective, that only 1 individual, Mr. Brakey, had any dog in the fight. The other 8 individuals failed the very first rule of grassroots activism. They didn't sign the petition. It doesn't matter how wholeheartedly you support something. If you don't sign the petition, you're not on the team. And that's what happened, Your Honor, with 6 of the defendants. The court recognized that they weren't part of the plaintiff, that they were improper plaintiffs. The defense maintains at this point that Mr. A.R.S. still isn't part of the team. The only thing that he did is show up when the record request was hand-delivered by Mr. Brakey. Mr. Brakey testified that, A.R.S. helped him draft the record request because he needed help with his dyslexia. Certainly, Mr. A.R.S. didn't have any access to the subsequent emails that were exchanged between Mr. Brakey and defendants, defense counsel, or he was basically just, Mr. Arellano could have been the chauffeur, the caddy. Me showing up to the White House doesn't make me a congressman. And Mr. Arellano's presence when Mr. Brakey hand-delivered the record request doesn't make him a proper plaintiff. Even though the defense failed in its motion to dismiss Mr. Arellano-Oros as a plaintiff initially, court still would ask it to conclude at this time that Arellano-Oros has failed to win his part of the case, Your Honor. And defense would ask for a judgment would ask for the court to find that he has failed to establish his burden of proof. Probably the most thing the court heard was when Mr. Brakey took the stand and had the Freudian slip, where he said, I gave them 10 days to respond to my letter. That was more telling than anything. This is his baby. He's the plaintiff. And you know what? Defendants recognize that. We recognize that. And the reason why that's important is because the attorney's fees are at issue, and certainly attorney's fees will be requested. And I'll even go one further, Your Honor, in an effort to be as candid as possible with the court. I believe Mr. Brakey is entitled to some remuneration because the county, the Secretary of State, basically needed a wake-up call. We were negotiating back and forth. You'll notice, and the court can read between the lines, you'll notice that the public record request was addressed to the Board of Supervisors, Miss Me. The response from defense counsel was actually to a different attorney, Mr. Mark Larkin, on August 7th. That's where the paper trail ends, Your Honor. And based on that, Your Honor, the fact of the matter is that we only have one real plaintiff here. And it's not Mr. Arellano or Oros, it's only Mr. Brakey. And that becomes important because, again, we got 2 counts on the complaint. Count number 2 is referring to allegations or requests number 1 through 4. Defendants submit that they failed entirely. Any of the defendants failed on numbers 1 through 4 for count 2. With respect to count 1, defendants argue that, you know what? They failed again on counts number 1 through 4. On 5 through 9, it may be a draw. The court still hasn't decided on count number 10. But at any rate, with respect to the 8 plaintiffs improperly pled, defendants have prevailed in its entirety. And the reason why all of this becomes important, Your Honor, is because attorney's fees are up for grabs, but they're not mandatory. The statute explicitly says that the court may award attorney's fees to a party that substantially prevails. Cesar Parada didn't prevail at all. Neither did Jack Sholnick, neither did Ruth Madison, neither did Jesus Olguin, neither did Olga Valdez, neither did Americans United for Democracy, Integrity, and Transparency in Elections. They didn't prevail at all. They prevailed nothing. In fact, defendants prevailed 100% against those seven defendants. Against those 7 plaintiffs. With respect to the other 2 plaintiffs, John Brakey and Sergio Arellano Oros, didn't prevail or shouldn't prevail on requests number 1 through 4 because there's been no testimony to rebut what Ms. Meek said, that they don't exist. With respect to requests 5 through 9, Mr. Brakey could definitely argue that he prevailed, again, with the understanding that 5, 8, 9 are extremely redundant. I don't believe that Mr. Arellano Oros should be allowed to prevail on numbers 5 through 9 because he never made a request. With respect to number 10, again, I don't believe plaintiffs should prevail on that issue either, simply because it's not a public record, Your Honor. The state maintained that the server is not connected to the local area network, was an adequate response. Requesting access to that in a secured location is not something that has been contemplated by a statute or case law to fall within a public record, even if it is something that falls within the record. And I'm almost done. So again, the court may award attorney's fees to a party that substantially prevails. And I just like to, statute doesn't come out, or there's no case that in this situation necessarily comes out and defines what substantially prevails means. However, the state would argue that substantially prevail shouldn't be 5 of 10 or 4 of 10. That's not substantially prevail. And even if it is, that's only vis-a-vis Mr. Brakey. That's not vis-a-vis the other 8 plaintiffs. They shouldn't be afforded any type of attorney fees for having not done anything other than allow their name to be added to the complaint. And finally, Your Honor, defense just wants to point out again that not only is there's the qualifying language that the court may award attorney's fees, there's also the language that it substantially prevailed, but then the third qualifying phrase in that statute is reasonably incurred. Your Honor, we're here today, especially with respect to numbers 5 through 9. We're only here today because the defendant's motion to continue was denied. If this had run the course of a regular civil case, if we had 20 days to respond, that initial week was sufficient for defendants to reach out to the Secretary of State and say, hey, listen, this Brakey guy is serious. Yeah, he's been sending some snooty emails back and forth, but he's actually serious. He actually hired an attorney, he filed a complaint, he served process, and now we're into it. And that was the wake-up call that that the Secretary of State needed to put its resources behind the county and help put us in contact with the expert witness that was able to do his own independent investigation of numbers 5 through 9. And defendants would posit that any fees incurred after that initial complaint aren't reasonable, or at least a significant portion of them aren't reasonable, simply for the fact that, you know what, defendants were forced to proceed, not only without having the opportunity to marshal a defense and contact an expert witness and contact the state adequately in order to get a mount of sufficient defense, but we also, again, I'll remind the court, were forced to proceed without the ability to even speak with the Board of Supervisors. And by way of background, the court is aware, and I know counsel mentioned this before, that a Board of Supervisors can have an emergency meeting with 24 hours notice. But Your Honor, that's not the way that this case started. The case started that we had a stipulated continuance, that we weren't going to go forward on, I believe, I can't remember the date, that we weren't going to go forward on the first day of hearing because we had a stipulated agreement to continuance. Unfortunately, scheduling is what prevented us from executing that continuance. But at that point, there was no reason to have a meeting because we were doing our best to prepare ourselves to understand the situation, and we were forced, again, to proceed with this without having the benefit of even contacting the defendants to have them weigh in. And that, Your Honor, unfortunately, it kind of snowballed, and that's why any submission of attorney's fees are going to be significantly higher than they would have been and could have been had that continuance been granted. And I would ask the court to take that into account, Your Honor. So, in sum, Your Honor, all of the plaintiffs have failed on requests number 1 through 4. Defense argues that all of the plaintiffs have failed on request number 10. Request number 5 through 9 overlap considerably, but to the extent that the court has determined that those are public records and metadata and data, Mr. Brakey may have prevailed on 5 through 9. But certainly Mr. Arellano shouldn't prevail on number 9. And even less so, all of the other 7 plaintiffs who shouldn't prevail on anything, Your Honor. And for that reason, the defense would ask for the court to take that into account and render judgment accordingly. Thank you. Your Honor. And before counsel begins, I did address attorney's fees today because it was my understanding that the court was going to make a determination of whether or not they're appropriate. However, defendants still would like to reserve the right to address the amount of attorney's fees. Again, I believe that it would be appropriate to either have an evidentiary hearing or a briefing to that effect where the defense could actually review the bill submitted by plaintiff's counsel to determine which portion of the bill is attributable to Mr. Brakey and which is attributable to the other plaintiffs. In addition, I think it would be appropriate to understand the timeline of the services rendered by plaintiff's counsel. Again, because it's defense position that what led up to the lawsuit is one thing. What happened since the lawsuit was actually filed and actually the hearing proceeded, certainly the court could take that into consideration based on the reasonableness of the fees and the reasonableness of the parties' positions in how this matter proceeded. So, thank you.
That is the process.
Your Honor, before we begin our rebuttal in earnest, we'd like to correct the defense on one very, very important point of law. I'm going to read directly from Phoenix New Times v. Arpaio.
Can I understand?
An agency must make a good faith.
Cite first.
Phoenix New Times versus Arpaio. Do we have a case set on that? It's going to be 217. Oh, Don here.
No, I think it's Don, come on.
here, but. Do you have the?
Okay, yeah, it's gonna be, the site on that is gonna be, could you make sure the screen is on? Go on, Your Honor, it's telling that defense spends so much time on the parties issue. Of course, from, I think, the perspective of all plaintiffs, there's a winner, or two winners, or 9 winners. The winners is every resident of this county, because the information will be disseminated widely, has been disseminated to everybody. Plaintiffs have access to this information, whether they were dropped or not dropped, so everybody got what they were going for. And the interests of transparency have been served. Honestly, Your Honor, if the plaintiffs had come to us and said, well, you drop everybody but one plaintiff and we'll give you the records, I think everybody would have said yes on that. The point was to get the records, not whose name was at the top of the ledger for the case. With regards to the continuance issue, it's not something that Arizona law provides for. Arizona law provides for these things to be brought as special actions, and those are accelerated actions, and especially in the face of an election. Time is of the essence in getting these sorts of election-related records. Now, the other thing that the defense is being strong about is the fact that this constructive contract was never requested. They continue to say over and over, no evidence of contract with Run Banking, no evidence of a contract with Run Banking. And of course, you have in evidence Exhibit 7, which is the email to John Maynard dated August 18, 2014, where plaintiffs clarify, as they testified that they had clarified, that it's with Run Banking or whoever prints the ballots. Or electronic copy of electronic invoice to Run Banking that shows how many ballots are being purchased in 2014 primary, or whoever prints the ballots. Because at that point the county had come along and said, brought up this Run Bank issue, and that was the attempted clarification. And it simply wasn't good enough for the defendants. Okay, now I get into another legal issue where they said, well, plaintiffs have failed to prove that with regard to 1 through 4 that the records were not properly maintained. Again, we had read during our opening statement this, and we'll read it again. Heads of each state agency must perform the following duties. 2, make and maintain records containing adequate and proper documentation of the organization, functions, policies, decisions, procedures, and essential transactions of the agency. And if buying ballots isn't an essential transaction of the county recorder's office, then I don't know what is. So in our case, our argument is this is sort of a res ipsa situation where the fact that we even have to look for a constructive contract speaks to the fact that the county violated the second provision of the statute. Now to the meat of the awards. County is arguing that the award of fees is discretionary, and that's incorrect. It's mandatory in this case. A.R.S. 12-349 provides for the mandatory award of attorney's fees and costs where a party brings or defends a claim without substantial justification. County's clearly done that here. You heard the county admit last week that they had now checked with the Secretary of State and with their own computer people and had come to the conclusion that almost all of plaintiffs' requests were denied. Your Honor, the appropriate time for the county to perform that sort of checking was when plaintiffs initially submitted their records requests over 3 months ago. They complain about the lack of time. They've had 3 months to do the appropriate checking, and it's their job to do the appropriate checking. The appropriate thing for them to do is not to yank plaintiffs' chain for 2 months, force them to lawyer up, force them to file a lawsuit, and only then to investigate granting their request. As you've heard during the first day of the trial from the Deputy County Attorney's own lips, defendants consider anything short of filing a lawsuit to be cheap talk. Well, Your Honor, talk may be cheap. Filing a lawsuit and seeing it through to trial is very expensive. And since the county would not place any value on talk, the law now demands that they must pay for action. But even if this court decides that fees are discretionary, they should still be awarded. A.R.S. 39-121.02 provides that a party that has substantially prevailed in a public records action may recover attorney's fees and costs. Again, there's no clear case law hammering out what substantially prevails entail, but there's plenty of case law to the effect that being granted some, or even a minority of requests, as long as it's an important request, constitutes substantially prevailing. We would argue being granted 5 through 9 is the meat of this whole matter, and we've certainly prevailed on that, because 5 through 9 is now in plaintiff's possession. But it's also worth noting, as you conduct your analysis, Your Honor, that bad faith and arbitrary and capricious conduct on behalf of defendants is actually no longer required for an award of fees under A.R.S. 39-121.02. Simply substantially prevailing is enough. Now, the defense has also implied an argument that the fact that their disclosures occurred via stipulation rather than through final judgment through the merits somehow undercuts our argument of having substantially prevailed. Again, we would direct the court's attention back to Phoenix New Times versus Arpaio, which is a case that's almost uncannily on point. In that case, Plaintiff New Times submitted a public records request to the sheriff's office, and after being yanked around for a couple of months, decided to file a public records action. Almost immediately after the filing of the action, defendant sheriff's office disclosed the requested records to the New Times, and then the trial court decided that fees were not to be granted, and New Times appealed. On appeal, the Court of Appeals decided that the simple fact that they were disclosed after the filing of the lawsuit was not enough to cut off an award of attorney's fees, and actually remanded back to the lower court for reconsideration on the fees issue. So that certainly will not serve the defense well here today. There's also strong precedent for the award of fees and costs in a case like this. In our research, we were at a loss to find a case where fees and costs, even under 39-121.02, were sought. Plaintiffs were determined to have substantially prevailed, and fees were not awarded, and the appeals court did not remand back to the lower court for reconsideration on that issue. So if it is permissive, the appeals court certainly have made their preferences clear as to what is to be permitted. And again, we would submit the example of Phoenix New Times versus Arpaio for the court's consideration in that matter. Finally, equity demands an award. It's a bit of sleight of hand to say, oh, well, some plaintiffs prevailed and some didn't, so plaintiffs should only get the award of the fees incurred by John Brake or Sergio. We would actually say to that, sure, Your Honor, give only the fees awarded to plaintiff John Brake, give only the fees and costs incurred by plaintiff Sergio, because all plaintiffs have signed a letter of engagement prior to the commencement of this representation, stating that if any plaintiff substantially prevailed, they would all agree to be held liable for fees and costs. So each one, and not only that, but they also all agreed to be held jointly and severally liable for fees and costs. So actually each remaining plaintiff, as well as all of the dismissed plaintiffs, are liable for the full amount of fees and costs. Giving any one their due gives all of them their due. And on the issue of equity, we would just return to the point. Your Honor, this action was entirely unnecessary. If the county had simply agreed to meet its legal obligations at the outset, if they had even performed research, the adequate research that they never performed over the 2 months before this lawsuit was filed, which would give them plenty of time to do it, since they managed to do it about a week after the lawsuit was filed, this action would never have been brought. No fees would have been incurred, no costs would have been incurred on plaintiff's part, on the county's part. And the fact that the county refused to do that, refused to do their job, means that they should be the ones liable to pay, not the plaintiffs who brought this action just because they want to see transparency in their county. I would say simply that county has done wrong. They had time to remedy their wrong. In fact, before actually filing the action, plaintiffs had reached out to the county, and since this is a discussion of fees, we could bring up the settlement offer that was made to waive all fees, to waive all costs for plaintiffs, to bear them all prior to the filing of the action. The day before the action was filed, that request was submitted. If the county would simply agree to disclose the records in their possession and stipulate to the records that were not in their possession, and that deal was turned down by the county. So that just speaks to the pattern of unnecessary delay that gets back to the mandatory aspects of the fees that have been, that has the pattern that has been followed by the county. Other aspects of this unnecessary delay, refusing to waive service of process and making plaintiffs incur that expense. That was an unnecessary delay. There was a settlement offer made before the Board of Supervisors meeting, and as the defense has pointed out, the Board of Supervisors calling me in 24 hours notice. The fact that none of that was done, it's just delay, Your Honor. And at this point, I think it's over the hill for the fees to be mandatory. So with that being said, Your Honor, we are done. And so one more thing to be said is in our view of the analysis of what fees are reasonable, defense is called for briefing on that situation. We would leave that to the court's discretion. We think that the court is fully capable of parsing the timesheet, parsing a list of expenses, and determining what's reasonable for its settlement. Where of course we'll be happy to accept, whatever the court would decide on that matter. So.
Mr. Holman? Final comment?
Pardon?
Final comment?
Your Honor, I do think it would be appropriate to address, for the parties to brief, especially the back and forth that went of the settlement negotiations with respect to the appropriateness of attorney's fees. Again, defendants aren't unrealistic in their understanding that the court won't award Mr. Brakey something for the effort and expense that he's gone through to bring forward this public record request. Having said that, as recited by counsel, the back and forth of those settlement negotiations, defendants have a different recollection of that, at least in my involvement back and forth. The board, there were several settlement offers that went back and forth. However, the timing of those is different according to the defendants than what was presented by plaintiffs, and I think that will become appropriate for the court to assess when determining whether or not fees are appropriate, or whether or not the amount of fees that the court deems are appropriate. I would also just finally cite by the case, I believe I cited already, the Democratic Party of Pima County versus Beth Ford, and that's 228 Arizona 545. Attorney's fees are most definitely in this court's discretion. It is not mandatory. And that simply is because Title 39-121 is a specific statute, whereas Title 12-349, referenced by plaintiff's counsel, is a generalized statute. And in general civil litigation, again, the other one is 12-341, which is also a general civil litigation statute, whereupon the prevailing parties typically are awarded attorney's fees. Because 39-121 is a specific statute, the case that I just cited makes specific reference to the fact that it is discretionary. It most certainly is discretionary in the courts. And again, the defendants are trying to take a reasonable position, and as we'll bear out, as we divulge to the court the exact nature and timing and amount of the settlement negotiations, the court can determine that the defendants have acted reasonably, and based on that, the court would, the defendants would ask the court to take into account how much attorney's fees to award, and it is most certainly important to defendants that that award be to the appropriate party. Defendants have not glossed over the fact that we're sued by 9 individuals, and if they're all for one and one for all, then they only needed 1 name on the complaint. But they did. They had 8 names on the complaint and an unincorporated association. And based on that, Your Honor, it's not a light matter for the court to have to parse out which party prevails and which party was improperly named in determining what an appropriate award of discretionary attorney's fees would be. Thank you.
Yeah, Your Honor, I believe I've read the case that counsel was referencing with regard to the specific statutes, and actually that case was referencing different statutes, so regarding contract and the mandatory award of fees regarding contract. With regard to A.R.S. 12-349, the statute, the public record statute, is actually explicitly, if I remember correct, can you pull? I believe they explicitly allow that one, or at least there have been, that's not one of the specific statutes that's been deemed to have been excluded. We can take a look at that. Here we go. In the Arizona Attorney General's Agency Handbook, it has to say this about attorney's fees and public records actions. In lawsuits alleging the wrongful denial of requested public records, a court may award legal costs, including attorney's fees, to the requester if he or she substantially prevails. A.R.S. 39-121.02b. This does not limit the rights of any party to recover attorney's fees, expenses, and double damages that are authorized by other statutes, double damages and all the rest. Of course, referring to statute, to the mandatory fee statute that we had previously cited. So as you can see, the Arizona Attorney General believes it's allowed, even if the county does not.